I'd like to welcome everyone to this night's webinar. I'm so thrilled to have Liz Holmes and Gordon Holmes presenting on special needs planning. Liz is a special needs attorney, and Gordon is has worked on special needs trusts across Indiana for years and is one of the kindest and best-hearted men that I know serving the state of Indiana. So I'm so thrilled to have them on. So Liz, take it away.
Awesome. Thank you, Dr. Pratt. So I'm going to talk about all sorts of things, but before I get into those things, I like to let people know why I care. I let people know this all the time. You know, I'm forever talking about my brother, but it's important to know where and why we do this. I have a brother who has special needs. He has autism, Crohn's disease, dyslexia, and a case of being difficult at times, depending on the day and when you talk to him. But Matthew has been a very hard worker. He has a job at Lilly now and works in computer programming, but he has his challenges even though he's on the higher end of the spectrum. So my dad and I both have practices focusing on special needs because of my brother and because of our background. So it's more than just a vocation, it's a calling, and that makes it all the more special because of that. I have my own disclaimer because just like any other presentation, this is not a replacement for an initial consultation. My dad and I both offer free consultations, be it via Zoom, phone, or in person, depending on your preference and ability, to answer any questions and figure out how we may be able to help you. Often I find, especially early on in my practice, people are just afraid to meet with an attorney. I don't really think I'm that scary, but for whatever reason, my profession at times can be scary, I guess. So I like to remind people that I was Liz before the bar exam, and I'm certainly still Liz today. So while we are going to go over a lot of material today, and we're happy to help you answer questions of a general nature and then more specific questions in initial consultations, this is not a replacement for specific legal advice. The summary of topics that I'm going to go over are power of attorney, guardianship, special needs trust, and I'm going to briefly touch on ABLE accounts as well. So we're going to start with power of attorney. So often when somebody reaches out and they say, oh, I need a guardianship because my child is turning 18 and this is just what we do because my child has special needs. That's not always a foregone conclusion. One of the responsibilities as a parent, loved one, and definitely as an attorney advising somebody is to start with the least restrictive alternative. So if you've heard of supported decision-making, that's a new piece of legislation, although it's not a very new idea, that emphasizes all the more that you shouldn't just assume you should be jumping to a guardianship because it's not always appropriate. We all know that if you've met one person with autism, you've met one person with autism. It doesn't mean that just because you have autism or Down syndrome or whatever else the disability may be, that guardianship is always appropriate. So if you're over the age of 18 and you have capacity, meaning that you can be what I like to call a fully functioning adult, then a power of attorney is a great option for you. There are two different kinds of powers of attorney. There's healthcare and financial. If you have a power of attorney where you've designated somebody to help you pay your bills or make your healthcare decisions, it's important to know that so long as you have capacity, you retain rights, your own rights to do whatever it is you want with your own things. You are not trying to give your rights away to anyone. Now, of course, if you're incapacitated later, that might be a bit of a different discussion if they've taken over your banks and paying bills, et cetera. But in general, you retain rights, your own rights to manage your own things financially or healthcare, so long as you have capacity. Now that can also be a risk too, because if your loved one with special needs has personality, likes to be difficult, likes to have opinions, or likes to say the fact of the matter is, even if it's only an opinion, that's what we're managing right now, then they can fire you. They can fire you as a power of attorney and have a different document drafted pretty easily. But let's say that power of attorney documents are not an appropriate choice. Let's say that your loved one with special needs goes to the doctor and answers yes to every single question, even when they don't understand the substance. Then that's where we get into a guardianship discussion. And that's not always a telltale sign, but it's a good one generally. So guardianship, as a lawyer, I'm a pretty big nerd. I was a nerd before, and law school just made it even worse. But the definition of a guardianship is the fiduciary relationship between a guardian and a ward or other incapacitated person, whereby the guardian assumes the power to make decisions about the ward's property or person. So when a lawyer reads a definition like that, then we parse the words and we pull out the main terms. So fiduciary responsibility, relationship, guardian, ward, and incapacitated person are those main things. And I'm certainly not going to read these slides to you, but I just wanted to explain how we parse things because that's important when we're trying to guide a client. A fiduciary relationship is essentially when you're stepping in the shoes of somebody. So if you're serving as somebody's personal representative, or you're serving as somebody's trustee or guardian or power of attorney, those are all fiduciary responsibilities, which means that you need to act in their best interest. If you're serving as somebody's guardian, you are stepping in their shoes, you are them. That doesn't mean that if you're somebody's guardian, you shouldn't consult with them and see what they want, because that's still very important. And then a ward is essentially the incapacitated person. And I know incapacity is not necessarily the friendliest of terms, but it's one that the law, that's how it's defined in the law. So what does it mean to be incapacitated? Well, if you're incapacitated, you're unable to do a lot of things. And I find this definition kind of humorous because, at least in my profession, I can't speak for all professions, depending on the day, some of us may qualify as incapacitated. And so with that, I hope some of you are laughing, even though we're not really interacting on this call. But some of us aren't always making the best decisions all the time, and that's normal. So it's important to note that guardianship is not a mechanism by which just to avoid making bad decisions. It's one where you are stepping in the shoes of somebody else to protect them from themselves, because they are not ready to do everything by themselves, for themselves, without any help from anyone. They're not ready to be a fully functioning adult. That doesn't mean that they won't ever be ready to be a fully functioning adult. But often, you know, if there's a minor and parents are too busy to be parents, or if they're elderly and they have dementia, or if they're turning 18 and they're not ready yet, these are all situations where guardianship may be appropriate. So there are practical questions when thinking about guardianship. Is your loved one easily taken advantage of? My brother is doing better now, but through his life, he has not had a ton of friends because he tends to burn them out. And so it's important to be aware of that and be aware that if they're taken advantage of, or I should say if they could be easily taken advantage of. Do they long for friends? You know, I had a client who had her daughter got the SSI check and friends clung to her when that check came. And when they tried to spend the money and failed because mom had a limit on the account as to how much could be spent, there were no friends. Can they handle money? Are they responsible? Do they take care of their healthcare decisions? And this is not a matter of they choose not to. My mom and my brother, my mom does a very good job of managing my brother's care, but there are times when he doesn't answer intentionally because he knows my mom will. Not because he can't, but because he knows my mom will just take care of him. And that's been an ongoing discussion that we've had, because when something happens to my mom, Matt's going to need to be able to step up and speak for himself a little bit more than just assuming somebody else will speak for him. So it's something that he's been working on. Also, why 18? Well, when you're 18, according to the law, you're an adult. And so I had a discussion with a new client today of, well, when do we file? I generally do not file until I do not have the hearing, I should say, until they are 18. That is because under the law, how it's currently written, unless and until they're 18, you're already their guardian. So why pay for something you don't need? Now, I will prepare the documents if given enough time before they turn 18, but I generally do not go to court until on or after the 18th birthday, because according to the law, albeit vague, it expires automatically on the 18th birthday if you go in too early. And so while you might think you're proactively doing the right thing, you're not in most cases. So the process, what does getting a guardianship look like? Meeting with an attorney. And I know that might sound a little self-serving to say, but it's worth mentioning. I hope you don't get your medical advice off of Google and legal advice the same way. I know there's LegalZoom and you can get a will for $20 or whatever it is. I can't tell you how bad that will look. I wouldn't do it, much like I wouldn't get my financial advice off of Google either. So you meet with an attorney, and if it's a free initial consultation, all you're out is your time and exposure to bad jokes. Or, well, I think they're good jokes, but anyway. We start off with a physician's report defining incapacity. What is the challenge? Why are we doing the guardianship? And that's important that the physician's report say more than just autism or Down syndrome. You know, why are we pursuing this? Then we draft a petition, and then there's a lot of paperwork in between drafting the petition and filing the paperwork. But then you go to court. In the span of about 20 to 25 minutes, you can get a guardianship over a person. That's kind of scary to think in less time than you watch TV, you can get a guardianship. But if it's uncontested and your attorney is prepared, and you're prepared and you have all the paperwork, then it can be a pretty painless exercise. It's not Judge Judy. I feel like I disappoint people when I say that, but it's a pretty laid back process, and honestly ones that judges look forward to because no one's really fighting. Granted, there are guardianships where people fight and we address those too, but to the extent that people can get along, that's always great. And then we file necessary paperwork. So there's a lot of paperwork involved with guardianship, and you want to make sure that you get it right because it is easy to screw up. I've had to fix numerous guardianships from colleagues who, they'll do the guardianship, but they don't really know special needs law. And that can be a big challenge, especially when clients have already paid this other attorney money and maybe didn't get what they thought they needed or got too much. So that's the general process. Now we're going to move into special needs planning. So I know that I have a limited amount of time and I'm happy to answer questions, but you have to know that my dad and I attend numerous national conferences over the span of days. So a half hour is a great start, but it's certainly not enough to go in as deep as what some of you may want. And that's why we're offering the free initial consultations. As far as planning options, you do have the right to give an outright inheritance to your loved one with special needs. You can leave it in a non-qualifying, non-special needs trust if you wish. You can disinherit them, and you can leave assets to siblings. Any one of these options is an option. And we talk about this all the time with clients. I lay out all the options. I don't just assume you want a special needs trust. And I let you know that if you do an outright inheritance, they'll lose Medicaid. If you leave it in a non-qualifying trust, they may not be able to access the money until they're 35, but they won't have Medicaid. If you disinherit them, why are you doing that? You don't need to do that anymore because we have special needs trusts. And if you leave assets to brothers or sisters or aunts or uncles or whoever, know that life can happen to them and it may not end the way that you thought it would for your child with special needs. Enter special needs trusts. And to keep this simple and straightforward and try not to go too far in the weeds, no matter how easily I can, there are two main types of special needs trust. There's a first party and a third party special needs trust. And the threshold question is, whose money is it? For purposes of this presentation, I'm focusing on third party special needs trusts, which all that means is that somebody else put their money into the trust for the person with special needs. It is not their money. If mom and dad are leaving money for little Johnny who has special needs, or little Susie, it doesn't really matter. Because it started out as somebody else's money, it can go into a third-party special needs trust. Whereas if you receive an inheritance or a direct settlement or something like that, then first-party trusts, special needs trusts need to be in. The logistics of this is that anything can go into a special needs trust and will not count on the outside against Medicaid. One main advantage of having a third-party special needs trust is that there is no Medicaid payback clause in that, which means that upon someone's death, the person with special needs death, if there's money left in the trust, it does not need to go back to Medicaid in a third-party special needs trust, where it does in a first party. So I like to tell clients that I help with the what if to avoid the what now. It's great that we have the first party trust as an option, but who really wants to pay the state back if they don't need to, right? So the third party special needs trust is a great tool to use. There's different ways of setting it up. You can do it privately through an attorney such as myself. You can also do it through the ARC. The ARC is a great tool to use. There are pooled special needs trust and pool trust assets together and act as a whole. If you would like to be in control of your special needs trust, which you do have the option of, the ARC is not necessarily the best option, but it is one to consider depending on how big of a bench you have. And by that, I mean your backup people if something happens to you for your loved one with special needs. Just to briefly touch on ABLE, because I know I'm about out of time, Achieving a Better Life Experience is what an ABLE account is. It's a 529A account. It recently came into legislation because unfortunately, if somebody with special needs came into money, the only options they had before an ABLE was to spend the money down or put it into a first party special needs trust and have the IRS and Social Security and Medicaid all up in your business. So an ABLE account actually allows individuals to contribute money to one account that is exempt from public benefits and means tested public benefits, meaning that their assets and income count towards the eligibility of these benefits is what we're focused on for special needs planning. As far as the requirements, you have to have the disability onset on or before age 26. and you're limited to the gift tax exclusion, which right now it's $15,000. There are some exceptions if you're working, but for purposes of this presentation, know that there are limits. You can only have one ABLE account, unlike a special needs trust where you can have more than one. And ABLE accounts must be used for qualified disability expenses, which really are anything under the moon, as long as they're tied to your disability. The maximum amount is tied to the 529 limit per state. And if you go above $100,000, then your SSI is suspended, not terminated, but suspended, meaning you go above it and you go back down, and SSI should be turned back on. There is a payback clause, meaning a Medicaid payback clause in an ABLE account and a first party special needs trust. But if used for the right reason and the right goal, it can be very helpful. You know best. You know your loved one with special needs better than I do, better than my dad does, better than we ever will. And so I like to encourage people in these conversations and these presentations to remember that you come in being the expert on your loved one with special needs. And it's important to have that discussion, because if we were just drafting wills for people we didn't know, or special needs trusts or guardianships or whatever, it certainly wouldn't be as special or sweet. So I know that when I help families, and I'm sure my dad feels the same way, that we feel like we're being invited into your family. And it's very special that we have that opportunity and blessing. So Matt has a lot of facial expressions and lots of opinions, and it can be really easy to think he doesn't, but he definitely does. And so the point of this slide is to make you aware, in the event that you're feeling overwhelmed or, oh my gosh, I don't know anything. You know your loved one with special needs better than we do. And working as a team, I can't do the financial plan the way my dad does. I certainly don't do my own taxes. He doesn't draft the wills. He doesn't draft the trusts. We work as a team together to help you. So understanding your loved one's public benefits is really important, making plans for the future, starting to name the people who will advocate for you and your loved ones, because this isn't just about you. You need a power of attorney too. Right? This isn't just about your loved one with special needs, I should say. This is also about you. And then talking to somebody who focuses and specializes in this area of law versus somebody who tries to do everything is very beneficial to you. So with that, my contact information is here. My email is here. My office phone is here. We offer free initial consultations. I'm in Fishers, but we also do Zoom, phone, in person, however we can help. I appreciate your time. I hope that this has been helpful. And with that, I will turn the floor over to my dad to tell you more about financial planning.
All right. Thank you, Liz, very much. I'm going to now check the chat to see if there are any remaining questions. There is a question, I think, for you, Liz. Are you able to hear me?
Yes. And Amanda, the question, at what age can you start the trust? Any age. There's no limit with when you can start a trust. Okay. I cannot draft a special needs trust for somebody that doesn't have a disability, however, so note that, but there are other types of trusts that we can talk about. And as far as the access to the copies of the slides or a handout, I emailed Melissa my slides, and so she should be able to share those with you.
One last question that looks to have popped up. If you have a power of attorney and you die, can you appoint a replacement in your will?
Your power of attorney is only valid so long as you are alive. Your will takes effect upon death, so no, you will not be able to do that. Those are two very distinct and separate documents. Okay, all right, that's it for questions. So I'm sharing screen, and we're going to plunge into a thorough review of government benefits. And so encourage anyone that has questions as we do this to, and then Liz, if you want to keep an eye, let me know if there's something in chat. I'm gonna try to juggle, but okay. Government benefit programs and benefits. Thank you so much, Kathy, for the introduction. My focus on special needs goes back 22 years. Since we began our personal special needs journey. And we help families all over the state of Indiana from every corner of the state to deal with the financial government benefit issues, and then working with attorneys like Liz to deal with the estate planning and guardianship and other legal issues.
My disclaimer, of course, we're not all things to all people. We do work very hard to help as many families as we can. I'm a part of Mass Mutual. The local presence is known as West Point Financial, and we have what's called Special Care. It's a national program that I participate in that is to provide both education, as we're doing this evening, as well as support to families that have a family member with special needs. Most often it's a child, but these days, increasingly, it's a sibling. So just like Liz, a sibling. Okay. What government programs are available? And we're going to touch on all of these. There's SSI, or Supplemental Security Income. We will talk a little bit about the impact of employment. It's such a blessing over the last 22 years to see an increasing number of our consumers with special needs being in the workplace. And we're going to talk a little bit about how employment and government benefits work together. Also, SSDI, Social Security Disability, as well as the impact of employment on that. Something called adult child benefits, Medicaid, Medicaid waivers, and Medicare. So strap on your roller skates, because here we go. All right, so SSI, or Supplemental Security Income. It's a non-medical federal income supplement program funded by general tax revenues, not Social Security taxes. It's designed to help the aged, 65 and older, blind, and people with disabilities who have little or no income. Disability is expected to last more than 12 months or result in death, provides cash to meet basic needs for food and shelter. For 2021, and all these slides were just updated in the last 3 weeks to reflect 2021. The maximum benefit is $794 per month in Indiana, or $529 per month if the individual receiving the benefit is considered deemed or receiving in-kind support. That means someone else is helping with their food and shelter expense. There are also reductions for child support and employment, and we'll talk about those in a moment. Available resources must also be kept under $2,000. That's basically checking, savings, mutual funds, investments, government bonds, anything that's cash or can be easily converted to cash in the name of the individual receiving the SSI, 2,000. It's the same in Indiana for Medicaid. So you'll see 2,000 popping up repeatedly. All right, continuing on. At the age of majority, eligibility is based on the child's income, not the parents', although their statement of household expenses and contribution can affect the SSI benefit level. So if you have a dependent with special needs who has not been eligible for SSI because of your income or your assets, once they turn age 18, even if they are still going to high school, still living at home, in the bedroom next to you, you feel nothing has changed, because they're 18, they can likely start qualifying for SSI. As far as how the benefit is calculated, the first $20 monthly of any type is waived. That is $20 of income. After that, $65 of earned income is not counted. After that first $85, though, thereafter, $1 reduction for each $2 earned, unless still in school. There is what we call a student earned income exclusion. It's something a lot of people are not aware of, but it excludes the first $7,770 per year in earned income. This is the consumer, the young adult with special needs, with a maximum of $1,925 per month, especially if they were to work more full-time on a monthly basis, like in the summer. If they're under age 22 and still in school, and it doesn't have to be high school. They can be in like Ivy Tech, this type of thing, or technical school. But if they, again, are under the age of 22, they're in school, they are likely eligible for this exclusion, which makes prior to 22 the perfect time to explore employment, maybe get voc rehab involved and try different things to see what works and what doesn't. Because SSI that they may start earning at may start receiving at age 18 is going to be very forgiving of wages until they're 22, if they're still in school. This could be also a reason not to rush their exit from their secondary education experience, but to hang on an extra year or two in high school, especially if they're not diploma track, to experiment with employment at a time when it will not adversely affect their SSI. Child support, 1/3 not counted against them prior to the age of 18. Once they are age 18, it is a dollar for dollar reduction in their SSI monthly benefit for child support received. So if you have a child that's age 19 and a parent is still paying child support for them, then every dollar of child support received has to be reported to Social Security. And for every dollar of child support received, there is an equal measure of reduction against the SSI. So it is not a net financial positive in many situations for a child to receive child support beyond the age of 18, especially if they are eligible for SSI. Again, I invite questions, put it in the chat box. We'll do our best to cover them. And if anybody's watching, if you could let me know if there is a question, that's great as I plow on.
So if you started a 529 college choice plan before you knew your child had autism and parents' name, but child is beneficiary, should you transfer out to another child?
Okay, they started an ABLE or a 529?
If you started a 529 college choice plan before you knew your child had autism and parents' name, but child is a beneficiary, should you transfer out to another child?
All right, well, first of all, as long as the 529 is not a UTMA, it's not a Uniform Transfer to Minor Act account, which means it has not been funded with the child's money. That is, you didn't write a check off of the child's checking account or close their savings account to fund the 529. And you would know if you have a UTMA because in the registration, you would see that acronym, UTMA, Uniform Transfer to Minor Act. As long as it's not a UTMA, we're not having problems with Medicaid or Social Security with the presence of that account. So there is no crisis for moving it out quickly, but certainly you could do a change of beneficiary to another child or eligible person, or now as a result of the 2017 Tax Prevention Act and Jobs Creation Act, it is possible to roll a 529 over to an ABLE account. So that's an option. And I emailed Kathy earlier this evening because I have a thorough workshop that focuses on ABLE alone. And we're getting more and more questions about ABLE accounts these days, partially as a result of the expansion of ABLE accounts in the 2017 Tax Act. So you have a variety of options. Leave it alone if it's not a UTMA, change a beneficiary to another family member or even to the parent, and also to consider rolling it to an ABLE account, depending upon the situation. And that's where the individual consultation is so very important to gain a better understanding of your family situation as to which of those three options would be most beneficial. Continuing with SSI, consumer must be 18 or over if parents' assets and income are not to be a factor in eligibility. Monthly contribution toward food and shelter. There is a statement of household expense. It's a Social Security form. It is little known. Social Security does not put it out there in the public arena, but I'm more than happy to go through this worksheet with parents to help build a case for why they should be receiving the maximum $794 per month and to determine what your child's contribution toward household expenses should be. That's really key in getting the maximum benefit. In fact, I would suggest if there's anyone on the call whose child is getting the lesser benefit of 500 and something a month, we need to talk because in most cases, we can explain a strategy to get the benefit raised to the $794 per month. And let me tell you, almost $800 a month tax-free, both federal and state, really helps. Also, again, the $2,000 resource limit, the earned income maximum, what we call the substantial gainful activity limit, a limit you want to keep in mind for earned income for your child or dependent with special needs, $1,310 per month. It's really wise to be cautious and careful about that number in addition to the $2,000 resource limit if you're seeking to maximize on government benefits and supports for them. The earned income student exemption that we talked about can factor in. Child support is a factor. And also apply for SSI prior to age 22. Even if you've missed the 18, it's okay. So just like you could seek someone's assistance, such as Liz, for getting guardianship, even if they're 19 or if they're 20. They don't have to be 18 to apply for SSI or guardianship, but there are benefits in applying for SSI prior to age 22 if possible. Also be prepared to appeal. It's not unusual to have to do that, to get turned down at first. That's not the last word. Battle back, appeal. I can give advice on how to appeal, and there are also attorneys that do nothing but Social Security work, and we can get you connected as appropriate with a Social Security attorney. Okay, trying to get through the rest. SSDI is Social Security Disability, pays benefits to adults who have a disability that began, Social Security Adult Child Benefits, excuse me. That's for before 22. So if you have someone that is unmarried, a child or dependent unmarried, disabled prior to the age of 22, earning less than $1,310 a month, chances are they will be eligible for adult child benefits when a parent has a triggering event, that is death, disability, or retirement. Either of those three will trigger benefits for a child. These benefits far outweigh SSI. We do have adult children with special needs receiving adult child benefits of as much as $1,800 per month. Substantial benefits from this area, again, triggered off of a parent's retiring, dying, or becoming disabled. So retirement alone, it's important in terms of the decisions that you make. I had a husband and wife on a conference call this morning trying to decide whether to start drawing Social Security at 65, wait till they're at full retirement age of 66 and 4 months. So if you think Social Security and SSI is only a decision for your child, you're wrong. There's a huge ripple effect on decisions parents make with regards to Social Security, disability, retirement, etc. SSDI can replace SSI or be paid in addition to it. And then there are other limits. We're probably going to run out of time for going into all of this, but SSI can be a combination of, you can have Social Security, disability, and SSI, one or the other, depending upon the situation. When an adult child starts drawing SSDI, they become typically Medicare eligible 2 years later. At the bottom there, the bottom bullet point, unlike SSI and SSDI, or SSDI does not penalize for earned income. So as an example, a consumer can earn $800 a month from part-time work. They can do that while receiving $400 a month in SSDI while retaining Medicaid Waiver. It is possible to have it all. In other words, to have SSI, SSDI, Medicaid, Medicare, Medicaid Waiver services, voc rehab, and potentially even Section 8 housing or other services as well. So that's part of the individual consultation, how to maximize on all these opportunities. Because I have to tell you, government benefits over a special needs consumer's lifetime can be worth millions of dollars. It's understanding how to navigate the system and to advocate for your loved one that has special needs. Okay. Okay, Medicare is usually as a result of SSDI for a consumer with special needs. Once they receive SSDI, either off of themselves or off of a parent's record, then they become eligible soon after for Medicare. That does not mean they lose their Medicaid. Medicaid, of course, is healthcare, and Medicaid funds waiver services. Many of you have a child or dependent that is receiving Medicaid waiver services. If they are not, please explore Medicaid waiver services. It's important not only for the budget you get for waiver services, but it's also important for the Medicaid, disability Medicaid that they receive. It's a better form of Medicaid than your traditional SSI Medicaid. And also the disability Medicaid that comes with the waiver has a much more liberal allowance for employment. So again, if you have a child with special needs, but you've not looked into Medicaid waivers, please do so. Again, individual consultation, we can help. Provide an application, walk through the process, help you get going with that. It's also advisable to apply for the waiver before 18, or shall we say before you apply for SSI. Indiana is a 1634 state. That means like 36 other states in the country. We sign on to the federal guidelines. And therefore, once your child is age 18, they will have to have a pending application for SSI before they can apply for Medicaid or waiver services. So, okay. In Indiana, Indiana's got a great Medicaid waiver system. The wait is not terribly long for the family supports waiver, which is what most parents are pursuing for their child that have a developmental or intellectual disability or on the autism spectrum. And by the way, your child is eligible at a young age, regardless of parents' assets or income. So do not think just because they're not eligible for SSI, they're also not eligible for Medicaid or waiver services. From birth on, in many situations, you can apply for a Medicaid waiver for your child, regardless of assets or income a parent has. Okay, there's different waiver programs in Indiana. But I think most on the call this evening are probably focused on the waivers through the Bureau of Developmental Disability Services, which is the family supports waiver. That is by far the most popular. But we can, in a subsequent session, we can go into more detail on the different waiver programs, because as you can see, there is the family supports, aged and disabled, community integration, and so forth, with different systems for delivering these waiver services. There's also a children's health insurance program, birth to age 19. And there is also children with special health care needs in Indiana, which is birth to age 21, providing the financial criteria is met. Okay, so teaming is really important with special needs planning, working with a financial advisor such as myself and a special needs attorney such as Liz on a teaming basis, very important. As Liz observed, I can't do what she does, she can't do what I do, but together we're extremely effective at helping families navigate both the legal, the financial, and the government benefit issues. Okay, contact information for both of us is on the screen.